All right. Well, thank you all for being here this afternoon. My name is Carrie Burns. I'm Chief Strategy Officer here at the Bar Association, and we're so thankful to our speakers and our attendees today for this discussion on issue 1. We have 3 speakers with us this afternoon. The first is Senator Cecil Thomas. Before he was elected to the 9th Senate District, he served on Cincinnati City Council and as Executive Director of the Cincinnati Human Relations Commission. He was elected as Assistant Minority Leader and is Ranking Member on Judiciary Committee and Government Oversight, Health, Insurance, and Local Governments Committee. So we will hear from him first, but our other 2 speakers this afternoon, Kevin Werner, he is the Policy Director with the Ohio Justice and Policy Center. He joined OJPC in May 2019 and is the primary staff member responsible for policy advocacy and lobbying initiatives. And then we also have Kyle Stone. He is a Stark County prosecutor. He was elected as Stark County prosecuting attorney in November 2020. Prior to this role, he tried numerous cases as a criminal defense attorney. And so today, this is for CLE credit. So those of you who have elected to take that, please make sure you fill out the survey at the end of the program, because that's how we'll report to the court that you were here. We welcome your questions. We want to hear from you. Our speakers want to know what you're thinking. So please use the chat or the Q&A feature at the bottom of the screen. That is how we'll get the questions to the presenters. We're going to go through, Senator Thomas is going to give us an overview of what issue 1 is and how it got on the ballot this November. And then we're going to hear timed remarks from Kyle and Kevin, and then we'll have time for rebuttal as well. So we're going to keep this as balanced and as on time as possible. And then we do want to hear from you in the second half. So please make sure you have your questions ready. And with that, Senator Thomas, I'm going to kick it off to you to talk about issue 1. And you are on mute.
Okay. Thank you, and good afternoon to all who are on this call. I should say this Zoom. I'm State Senator Cecil Thomas, and I was a part of the vote regarding putting this issue on, allowing this issue to be put on the ballot. The way it got on the ballot, the reason we're having this discussion, it just goes back to a case where a person by the name of Dubose, last name was Dubose, there was an appeal regarding his excessive bail, and the local courts gave a $1.5 million bail. There were some discussions in local court that lowered it to $500,000, and then there was some additional discussions in court that raised it back to $1.5 million. And the defense attorney appealed that to the state Supreme Appellate Court, First District Court of Appeals, and they reversed the decision of the local court, basically saying that $1.5 million. Based on the issue of public safety and holding this individual in as a result of keeping the public safe was excessive, and they reduced the bail back to $500,000. Now, there was an appeal to the legislators. First, the executive branch of government under Attorney General Yost. There was an appeal from a prosecutor, local prosecutor, Joe Dieters, to discuss with the legislators to get this on the ballot, to change the way that bonds are set. That resulted in the legislature, the majority in the legislature voted to place this issue on the ballot regarding public safety as being a criteria for judges to consider when setting bond. And that's pretty much how it reads, the language reads. However, I'm going to give a quick summary of exactly what is being said here. The proposal to amend the Ohio Constitution to eliminate requirements that the amount and condition of bail be established pursuant to a specified provision of the Ohio Constitution by the Ohio Supreme Court, and to instead require courts, when determining bail, to consider public safety, including the seriousness of the offense and a person's criminal record, the likelihood a person will return to court, and any other factor the General Assembly may prescribe. Now I'm gonna give that in, let me break that down in a little more detailed analysis. What the resolution proposes is to amend a provision of the Ohio Constitution to eliminate the requirement that the procedures for establishing the amount and condition of bail be established pursuant to Article 4, Section 5B of the Ohio Constitution, and instead require courts when determining the amount of bail to consider public safety, including the seriousness of the offense and a person's criminal record, the likelihood a person will return to court, and any other factor the General Assembly may prescribe. That's the concern that is the concern here. And any other factor the General Assembly may prescribe. Now, what that basically is saying is that you're taking out a section of the Constitution that gave the Ohio Supreme Court the authority regarding this area of setting bail, and replacing it with the General Assembly. And that's pretty much the crux of what we're discussing here. Can judges consider public safety as a criteria in setting bail? However, we all know that that is part of the overall process of setting a bail. Judges currently already consider public safety, but they can't set aside public safety and say, we're going to keep you in jail, and we're going to put this high amount of money on you specifically because you are a threat to the community. There are other factors, and the judges have to take the totality of all of the factors into consideration. And the monetary portion is part of all of that. And so keep in mind, we're all innocent until proven guilty. That's the rights that are given to every individual under the Constitution. And so I'm just, that's kind of an overview. And so now I'll open up for discussion.
Thank you, Senator Thomas. And so Kyle, we're having you go first in the discussion.
Thank you, Carrie. Thank you, Senator Thomas, to Mr. Werner, Kevin as well, and to all of you who are participating in this. I come from the perspective of a prosecutor. And so my perspective is going to be slightly different, having been a defense attorney before being elected as well. So I can, my thoughts are from being on both sides. And so issue one, when we look at it and understand it, what the majority in that DuBose case rested on is that there was a change in the criminal rule 46 that took place in, I believe it was in 2019. It was submitted in 2020. And then because of the legislature didn't take any action overall for the changes, it went into effect in July of 2020. And so the majority's perspective and opinion was based on that the language of Rule 46 had changed, and it separated the evaluation or the ability of the local common pleas or the municipal court judge to consider public safety in the totality when considering bond as a whole. And so it separated it. And so when the majority stated their perspective, and the reason why they decided it was because of that new language in 46. And so what issue one is saying is we're giving that authority back to the local judges to be able to consider public safety in totality, all of it collectively and not separately. And so that's what issue one. Yes, there is language that adds that the General Assembly may prescribe more and whatnot, but that's the people have the ability to decide issue one, and then the people also have the ability to decide individuals within the General Assembly. And so issue one protects the community, it protects the people. I, for one, see it all the time when victims, witnesses call our office. I had an individual call me or leave a voicemail for me actually on Thursday and say how terrified she is of her boyfriend getting out of jail. Now, in this situation, he's already been incarcerated. So it's slightly different. However, that was just a very recent example of the phone calls and then the request that we get as prosecutors, because victims and potential witnesses are in true, genuine fear of their lives and their safety, and not allowing our judges to be able to consider that is why issue 1 is necessary. Now, that doesn't take away a person's ability to petition the court in the sense of excessive bail. That doesn't allow for excessive bail to take place. Those protections are still in place. All issue 1 does is really just give back to our local judges the ability to consider multiple factors, specifically the public safety, and allow them to evaluate that in considering bond, which from a prosecutorial perspective, we want that. We want to continue to protect. Our duty is to protect the community and protect victims and protect witnesses as well. And so we want them to be able to consider that when they decide bond. Like I said before, it's really, I'm really looking forward to the questions that the group might have. But at the end of the day, issue 1 for us is common sense for us. You know what I'm saying? Because we are in the thick of this. We see it every day. This is what we see every day. Even when I was a defense attorney, I saw it. The questions that I always had is, are the bails that's being set consistent across the board? That's really where, to me, the crux of the issue should be, is, are we being consistent across the board within our courts across Ohio, to where individuals, no matter their financial income or no matter their status in the community, no matter what, that we're being consistent across the board with our setting bails. And when we set one higher than the other just because of who they are, that's when the issue exists. And I believe that the real concern should be, are we consistent across the board, not whether or not our judges are considering public safety. They should be able to. We've been able to do that for many years within our criminal justice system. And so I believe that it's necessary for us to continue in that. And that's why issue 1 should get a yes vote.
Thank you, Kyle. And now Kevin.
Thank you. Bear with me, ladies and gentlemen. I hope the voice holds through. I'm experiencing a little bit of change in the seasons. I want to first say thank you to Kyle Stone and to Senator Thomas and Carrie and everyone for putting this discussion together. I do think it's really important. I think that, I want to start out by just saying, everybody wants safe communities. Everybody is on the same page about that and that concept. Where the fault lines are with this particular discussion are really going to be about how do we do that, right? So of course, the Stark County prosecutor and I are going to agree that dangerous people should be kept away from causing harm to other people. That is a least common denominator. That's not even a discussion. But what is a discussion is we have to think about what issue 1, the outcomes are, what the outcomes will be. And I think that I appreciate the way Senator Thomas set up the stage in terms of what actually has taken place. Ohio voters are being asked to vote on this constitutional amendment, and what they're being told is that the law has changed. Somehow the law changed as a result of a Supreme Court decision, which was referenced, and that was DuBose v. McGuffey. The law didn't change. The Ohio Supreme Court said, this is what the law is. This is what it has been for decades. This is what the purpose of bail is, to ensure a defendant's appearance at trial. I did a public records request that brought me lots and lots of documents. And so what I learned, effectively, Senator Thomas said this a little bit earlier, was that Joe Dieters, the Hamilton County prosecutor, did not like the decision in the DuBose case. And so he, through his office and working with the Ohio Prosecuting Attorneys Association, wrote the language revisions in issue 1. because they didn't like the outcome of the case. That is, public records requests demonstrate that. But what I really want to talk about and point out is what issue one will do is it will double down on the current system that Ohio has. And here's why we know that would happen. Number one, the DuBose decision did not do anything to public safety considerations. It didn't say judges are no longer allowed to consider them. What it said was judges don't use money to make a public safety consideration. You use non-financial conditions. There are different types of bail. There are non-financial conditions, there are monetary conditions, there are like property conditions, right? So there are different kinds of bail. What the Supreme Court says is money does not guarantee you public safety. But what issue one is attempting to do is exactly that. And the way we know that is because during legislative testimony and hearings, a judge from Hamilton County came to provide testimony and said, if I ever think that a person is dangerous, I jack up the bail. I increase the bond. I don't care what the Supreme Court says, I'm going to increase that. So here's the problem with that. What happens when a wealthy individual who is dangerous meets the bail that the judge requires? There is absolutely no mechanism in issue one. There's absolutely, it eviscerates criminal rule 46. It takes the legislature completely out of the rulemaking process. I'm sorry, it takes the Supreme Court out of the rulemaking process and gives it solely to the legislature. And so what will happen is more individuals will have to pay higher amounts of money, and the judges are going to have to kind of guess what's the threshold here? What can you not afford to pay? I better put that monetary bond above and beyond what I think you're able to pay in order to keep you detained pre-trial because there's a public safety consideration or concern. So that is not a good way to achieve public safety. And another reason that we know that this constitutional amendment is effectively doubling down on the already broken system is because the current law already allows prosecutors to ask a judge not to release someone on bail. Now, we can argue about whether or not that's effective. We can argue about whether or not the standard is too high. We can have that discussion. But for prosecutors to say, and I'm not saying Mr. Stone is saying this, but I'm saying in general, for the argument to be, we are no longer able to consider public safety when setting bail is patently false. It is patently false. So again, we don't have a disagreement about public safety. A yes vote doesn't mean you want public safety and a no vote means you don't. We all want those things. It's a matter of how do we go about getting to that mark. So I'm going to stop talking now and look forward to the questions or the rebuttal and then just the next pieces.
Thank you, Kevin. Kyle, would you like your rebuttal time?
Yes, just one thing I want to say is the Supreme Court decision in response to Kevin was that the Rule 46 changed. And currently under our Constitution, the Supreme Court is charged with deciding factors and specifics with regard to bail. And so when Rule 46 changed, that's what the majority basically in the decision hung their decision on, was that language changed. And because that language in Rule 46 changed and separated the analysis of it, that is where the decision was made. And so, yes, there was a change. It wasn't necessarily a change in the law, but it was a change in the rules. And because there was a change in the rules in response to it, some of our judges have, even when our prosecutors have said, well, for this reason, this individual, they say, nope, we can't consider that. And so in real life, every day working, our judges are under the perspective and under the reality that they cannot, when they're deciding bail, that they cannot consider public safety, which for many, many years, we've been able to do it. This was the first decision that changed that. And it was based off of the change of rules of the criminal rules of procedure that changed that, and not necessarily saying that there was a law that the Supreme Court is saying this is what the law is stating. They are basing it off of the change of the Criminal Rule 46. And so issue 1 is just saying we want to go back to allowing our judges to have that ability to evaluate the protection of the community in the totality of deciding bail.
Thanks, Kyle. Kevin, anything to add?
Yeah, very good point. I'm glad you brought that up because, you know, what we have to understand here is the rule changes to Criminal Rule 46 happened after the Ohio Supreme Court spent about a year taking a deep dive into the issue of bail. And as a result of that deep dive, and as a result of considering best practices, and as a result of considering what works and what doesn't, it made changes. And effectively what the direction that issue 1 is going to put monetary bail into the Ohio Constitution via a public safety consideration is the exact opposite of all the recommendations that were made by the Ohio Supreme Court. So again, we come back to this. We have an individual prosecutor who didn't like the ruling, and the outcome is, well, we can just change the law. 2 days after the Supreme Court decision came out, the executive director of the Prosecuting Attorneys Association asked half the members of the House Judiciary or House Criminal Justice Committee, they're looking for a legislative fix. We want to undo this ruling. So this is not necessarily about, this is not necessarily the best way to go about achieving public safety. And here's another way that we know this, another anecdote that allows me to think this really isn't about public policy. The initial unveiling of the constitutional amendment was slated to happen in late February. There were communications between folks at the Attorney General's office, folks with the Prosecuting Attorney's office that said, hey, can you hold off on this decision? We want to let the air clear with redistricting and with the Ohio Supreme Court. Now, if you're telling me on one hand that judges are in this position where they're not able to make public safety considerations, this is an emergency, then why are you saying let's wait a month? Let's wait a month on this announcement. So I don't disagree that this is the first instance where the changes in Rule 46 happening are sort of like, okay, let's talk about this. But what Rule 46 was changed to was best practices. The reason that you use non-financial conditions or when you make those financial conditions the least restrictive, so that we don't wind up with poor people being held simply because they can't afford their. So I would have shut up and let others talk.
Thanks, Kevin. Kyle, do you have anything? Would you like some time to respond?
One of the things that with regard to the announcement, sometimes I'm not sure if we can necessarily associate the politicalness of a decision to make that when it had to come on the ballot anyways. It was going to come in November anyways, whether it was announced in February or March, it was going to have to come in November. And so because of sometimes not causing more division, because the reality is this, there's support for this from a prosecutorial perspective, there's support from this from Democratic and Republican prosecutors, because once again, we're in a different position, we're in a different perspective, and we see things just slightly different than others because we see it every day. And so it has bipartisan support with other prosecutors. And so, you know, that's where we are.
Kerry,
Just a real quick thing. I want to believe that you know the timing of things does happen. But when I see communications that say, hey, can you hold off until next Thursday because we have a meeting and I want to get approval on this before we go ahead and bring this language forward, that tells me that, you know, there are some considerations that are being made that are outside of what is in the best public policy interest. I don't want to keep harping on this because That's not what we're here to talk about. But the process that this was set out upon, 5 days after this constitutional amendment had its first hearing, it was scheduled for a vote. That's not vetting. That's not, is this good public policy or not? That is push something through as quickly as you can to get us the result that we're trying to achieve.
Senator Thomas, did you have something to add?
Yeah, thank you, Carrie. But first of all, the true goal of issue 1, let's be real, it is to allow courts to set cash bails in the amounts that the rich can afford and the poor cannot. That's one area. The other part of this bill, it is to take a function that has been in the Constitution that has the control by the judicial branch, and take that function and put it into the hands of the legislative branch. In other words, you're encroaching on powers of the various branches of government. The reason the Constitution gives the Supreme Court that function, there are checks and balances. The Supreme Court has that function. Then there's the executive branch, and then there's the judicial branch. This function is under the auspices of the Supreme Court. That's dangerous to take that and put it into the hands of the legislative branch, because it clearly says that it was regarding any other, let me see what it says, and any other, it says, and the General Assembly may prescribe when determining bill as amended, and it's any other area that they consider as they may choose to. In other words, it's the end of this, it's wide open. It's an open-ended area. When you're talking about this whole issue, it's versus rich versus poor is what it boils down to. And I asked the question, what were these local courts doing before the Dubose case? And what they clearly was doing was they had a process by which they could ask if they felt that an individual was a threat. The prosecutors could go to the courts and have what is called a detention hearing, and the individual could be held without bond. That was that's the function, and that is how it's always been. So when I asked the prosecutor, well, what were you doing before Dubose? And I said, how many detention hearings did you have? He said, very few. And my question then was, well, if you only had a few, well, were you obviously satisfied with the process by which things were doing? The judges had the discretion. But if you're going to take this away, this is a dangerous area, and allow for monetary, financial, as part of a bail setting as the only criteria that a judge, that an individual uses. I should say, let's say it this way. If a judge says, well, I'm going to make sure you're not getting out because I think you are a threat, even though you're innocent until proven guilty, that is clearly in violation of the 8th Amendment of the U.S. Constitution, as well as the current Ohio Constitution. And one quick example, and I'll end it. I had a young man came up and testified. He was charged with aggravated robbery, and it was a one-on-one identification, and he was given a $1.5 million bond because the court said you are a threat to the community. He was found innocent, but he couldn't get out. He lost his scholarship to go to college. He lost his job, and he had to sit in jail for over 7 months until he was found innocent. That's the problem and danger of having monetary bond bail as a means to keep someone, as a means to try to say this is a safety issue. It is not a safety issue at all.
Thanks, Senator Thomas. Kyle, I've had a couple similar questions come in from a point we made earlier. We talked about the changes to Rule 46. Two questions have come in about, do you know how the Prosecutors Association, were they in support of these changes? Did they make comments when these changes were coming through?
I cannot speak to that. That was actually a really good question. I just can't speak to that. I can always reach out to Lou Tobin and inquire. He's the executive director, to find out, but I'm not for sure.
Thanks, I appreciate that. A second question, and this was one I had based on the conversation we were just having. Why was it designed that the legislature now has control over bail and bond requirements? What was that a specific intent to change that? Because it seems like the court would be better suited as the judicial body, like Senator Thomas said. And Kyle, I'll start with you on that question.
I think part of it was because, and to Kevin's point, when he talked about individuals with best practices, making those changes based off of the need for a bail reform, I believe that was the auspices based off of the decision making and whatnot. And one of the concerns is when prosecutors alike have a different perspective, I question whether or not it's the best practices for everybody that's included in the judicial system, whether or not everyone was included in that process and whatnot. I've sat on a committee for Supreme Court here just recently, and they generally have a perspective in mind with those committees. And generally, if your opinion or perspective is opposite of theirs, it's not always received as you would want it to be. Now, that doesn't mean that they don't hear it, that they're not listening, but it's generally you kind of have a perspective. And so I believe that in that situation, in understanding that rule change, that was best practices for some, depending on the view. And so here we're saying as prosecutors, that's not best practices for us. This changes things, and it's not about poor and rich. I disagree with that respectfully to Senator Thomas, because I work with the judges here in our county, and I also, as a defense attorney, we had a young lady who was charged with murder. She had $1 million bond. We petitioned the court. She was given $1 million bond in the municipal court. And then we went to the common pleas court, expressed why we felt her bond should be lowered, and it was lowered to $200,000. I haven't seen personally in Stark County, I haven't seen our judges arbitrarily increase someone's bond excessively in order to keep them in jail or to, just arbitrarily. I have a situation here locally. I'll use this example. There was a young man who's from March up until October had 5 open cases with us, and 3 of which he got pulled over with a felony 2-level drugs, fentanyl, and those things in his possession. And every time he's driving with no license. And finally, because of who he, because he's continued to violate the law, because he's continued to do X, Y, and Z, he got a higher bond, or a bail amount was set higher because of his continued disregard for not only the law, but also, he's continuing to deal drugs. He's continuing to do and bring harm to our community. And so I believe it's necessary for our judges to be able to at least consider those factors. Now, in this situation, they increased his bond initially. Now, I'm not for sure if it's been lowered since then because I haven't followed it, but just within like the past 3 weeks, we see people who they make the bond, then they get out, and then they continue to do what needs to be done. And we want to allow our judges the ability to consider all factors when deciding bond moving forward.
Carrie, can I comment on that?
Yeah.
we keep referencing Rule 46 and the change that took place, some of the changes that took place. There were 3 changes that took place in Rule 46, and I'll read those very quickly. It says that Rule 46 has been amended to improve efficiency in setting bail in an amount that effectively ensures, 1, the defendant's continued presence at future proceedings. 2, the future proceedings will not be impeded by any efforts to obstruct justice. And 3, the safety of any person as well as the community in general. In other words, the courts, the Supreme Court has consistently addressed the issue of bail reform. In other words, we all know that there's some serious problems with bail, and it's not something that you can say one size fit all. You can't do that. And they clearly have consistently, through best practices around the country, through all of the efforts with bail bond reform subcommittees, all of that, and I'm on that committee, consistently find ways to better serve the community. Public safety has never been an issue that's not been considered by judges. And there's criteria by which that is allowed to be considered. And I keep hearing considering public safety and all the other areas. Well, they've been doing that all along. And I was a police officer for 27 years. And they always considered public safety. And then add to that, that was the opportunity. If this individual was truly a threat to public safety, the detention hearing allowed for the judge to establish a no bond. The judges have been always had that that method of setting bail. And so I think we need to stay focused to take this out of the Constitution and to put something in the Constitution that gives that authority to the, give that control, if you will, to the legislators. That's a dangerous precedent.
I just chime in here on something that I just want to underscore this, this sort of separation of powers and what's really the best practice. I think it's a pretty objective statement that changing the bail practice and policies to putting them under the legislature is diminishing the separation of powers. Like it is, I think that's a pretty non-controversial statement. But the outcomes are what really concern me. And here's an example with what other conditions the legislature may set, right? The legislature is in complete control of this bail process, right? From this day forward, assuming, or if issue 1 were to pass. In 1974, Title 29 of the revised code had 146 felony offenses. In 2020, there were 752 felony offenses. So the track record is that the legislature increases offenses, increases penalties for those offenses. And so when you allow the state legislature, who is already predisposed to enhancements and creating more offenses that carry greater prison sentences, it follows that same trend is going to be applied in the bail setting. So what I worry about is that instead of having a 30,000-foot conversation, a philosophical conversation about what's the best policy, the legislature is then going to run down the track and to make more and more and more conduct perceived as dangerous, even though, you know, substantially similar circumstances and behavior it's this offense and it's that offense. These are the same things. So my concern is what happens when the legislature decides that it wants to change what it deems to be an offense of violence. I'm not condoning violence, but I'm saying that those are definitions that change over time. They tend to increase. So I think that what we could reasonably expect, and this is not a rocket science type of thing, Ohio jails are going to, their population is going to increase. That's going to put more strain on local resources. I think you start to have these conversations about, do we need to build a new jail? And so those are the kinds of outcomes that we're concerned about.
Thanks. A couple questions have come in about how the law stands today without issue 1 on the table. How are offenses of violence protected now? Is there a public safety factor consideration today? And Kyle, do you want to start?
Yes, so there is, and like Senator Thomas stated, judges have always considered public safety. The difference is it with the change and with the bowls, it separates. It says you can consider public safety, but when it gets to the bail amount, setting the bail amount, you can't consider it. And so previously, it was the judges had the ability to consider it all as a whole. Now the rule with the new updated rule of 46 is it's like you can think about it, you can consider it and take it into account. But when it comes to deciding the bail amount, you can't consider public safety. And so that's where we're in disagreement, basically, is we're saying that judges should be able to do like they've always been able to do and consider it all at the same time before deciding on the bail amount. And instead of having to contemplate it, but then can't have that consideration when making the final determination on bail.
Yeah, I think what I would just respond with is, again, the public safety considerations as they stand today they haven't changed. The Supreme Court said when you're making public safety considerations, you use non-financial conditions, because what we've learned is that the amount of money that a person does or does not have has zero correlation to are they a danger to a person or a place. So I respectfully disagree with the characterization, because there's a comma. There's a comma. And in order to consider public safety, you use non-financial conditions. You can't use cash as a way to keep someone incarcerated in before trial. Because what we have to remember is that, I think, one of the beauties of this country is some of the case law, right, that has come down. The U.S. Supreme Court case in U.S. v. Salerno, Chief Justice Rehnquist writes something like, in our society, liberty is the norm, and detention with or without trial is the carefully limited exception. Issue 2 turns that on its head. Effectively, that's what it does. So the long-held belief, the long-held concept was we value our liberty. That's the norm. And so Ohio's current system, I think, when you read about these cases where an individual cannot afford a $74 bail, and we know things like a person who is detained pre-trial is more likely to plead guilty, right, regardless of whether or not they're innocent or not guilty or guilty. They're more likely to be convicted, right? They're more likely to have their they're less likely to have their charges reduced, and they're more likely to receive a harsher sentence. So is that the system that we want to double down on? That's my question. I think the answer is no. But enshrining welfare-based detention into the Ohio Constitution is just not an appropriate public policy, and the problems that we are going to have down the road are enormous.
Carrie, also, let me jump in.
Can we let Kyle respond first?
Oh, I'm
Senator
sorry.
Thomas?
Absolutely.
Yes, so one of the things that it is important is understanding that. So we have this wonderful protections in place that people have 90 days from the time we indict a case up until we have to go to trial, 90 days. And it's a bigger issue here that is beyond this. And it's the system is broken. There's some changes that need to take place in the system. And the responsibility rests sometimes on the attorneys that we hire, the representation that we have to fight and advocate. I've personally seen some, we have this term called bleed 'em and plead 'em, where attorneys will bleed people of the money and then get them all the way to almost to trial and then convince them that they have to plead. And so there's a greater issue that exists that's not just about issue one that needs to be evaluated, needs to be addressed. And I think that's sometimes where we try to use one thing to, and I'm not saying Kevin is doing this or Senator Thomas either, but sometimes we'll use one thing and try to hopefully achieve the overarching goal of reform to a broken criminal justice system. Yes, there are some people who have languished in jail because they didn't have the money for bond. There are some individuals and some injustices that have taken place, and we continue to fight for them. I fight for them now in my office. We continue when those things are presented. We try to follow the law. We do what's right. We have these things in place, and I'm not aware of any prosecutor's office or any judges that are allowing prosecutors to not try a case within that 90-day period unless the individual has signed a time waiver based off of the recommendations of their defense attorney and whatnot. And so I don't see it, and that's not saying that it doesn't exist. So I respectfully say that I don't see that currently here in Stark County. Has there been some wrongful convictions in Stark County? Yes. Has there been some people who have pled to some cases or feel obligated to plead just so they could get out or just so they can be done and get time served? Yes. But people like myself who, when I ran for office, it was, we're not going to allow overcharging to take place at the indictment level. Those are the things that have to be changed and adjusted in order to change the system. And I think issue one isn't is it going to reverse or fix or adjust the attempts to fix it, because I believe that the change in Rule 46 is not the fix for the broken system. I believe that there's some more work that needs to be done, but the changes in the language that has changed in 46 wasn't the answer. And I believe that we still got to get back in supporting issue one will help us get there, but still these conversations should continue to have, so that we can find a resolution to fix a system that we all know has some holes in it and that's broken.
Carrie?
Senator.
Yeah, thank you. That's a perfect segue into what I was going to jump into. There's consistently a need for a moving target, if you will. The criminal justice system is an extremely complex system, and the last organization you want to manage that process is the legislature. I'm just being real. However, this is why the Supreme Court has the wherewithal to do all of the research and to come back with recommendations for change. I'm going to quote a very good friend of mine, Tim Young, who's the state public defender, head of the public defender's office at the state level. And he basically said, public safety is not achieved by setting high cash bail and just hoping a person cannot pay it. Public safety is achieved when prosecutors prove to the judges that a person falls into a carefully limited definition of dangerous and should be detained pre-trial. That's how things have been done. And it's up to the prosecutor at that detention hearing to argue specifically why this individual should be held without bond, or why this individual is a threat to public safety. That's a function of the prosecutor's office. And so I say that to say that when we reverse this, if you will, and we find ourselves turning the Constitution on its head in terms of innocent until proven guilty. You're doing something, and you're going to put someone behind bars because we got this open-ended legislature that then says, here's what is considered an individual that's a threat to the community. And that could be almost anything that they choose to, and that becomes problematic. You got to rely on your people who are charged with this responsibility and who has all of the resources at their disposal, which is the Ohio Supreme Court, the judicial branch, to manage this process.
I guess the only final thing that I would just want to add that it goes back to with what Kyle was saying, and I really appreciate what I would categorize as a different approach, right, to solving some of the problems. We're not going to overcharge, like that I think is wonderful, because I think that for a long time I think that was a practice that was just all too common. What we come back to is this idea that if we're going to reform the bail system, if we're going to make changes, then we have to consider the context, right? The context is, was it 60% of America cannot afford $400, cannot come up with $400 in the case of an emergency. It takes just about 4 days of a person being away from their family in pretrial detention for their life to fall apart. They lose their home, they lose their children, they lose their job, and then they're in this position to where they'll just plead guilty to whatever just to get out. And then they're stuck with decades of collateral sanctions because of the underlying guilty plea. And so again, doubling down on the notion that if we use money to determine who is not a public safety threat and who is a public safety threat is only going to exacerbate that exact problem. That's our concern with issue 1. That's why we are not in favor of it. We think that the outcomes we currently have are terrible, and that issue 1 is going to exacerbate those problems.
Hey, Carrie, if I could just add one thing.
Please.
One of the largest that we see when judges are considering public safety are generally for very violent crimes, as well as crimes like domestic violence, or individuals who have been charged with multiple counts of child molestation or different things like that. And so we don't see and once again, I'm only speaking from the limited perspective of Stark County. I can't necessarily speak from all of Ohio, but what we don't see is judges utilizing, because we understand we've elected these judges. They generally operate with integrity. They generally operate with objectivity overall. And so when it's presented to them, public safety concerns generally are only evaluated or are most important in cases when individuals have been charged with serious crimes. And we do have that option of no bail, but even that is limited. Not all crimes that might rise to the level that cause concern for the community rise to the level or fall under the statute where they can have a no bail. And so I hear the thoughts and the perspectives of those in opposition of issue 1. I hear it, I understand it, but like I said, from a prosecutorial perspective, we see it all the time. We see how individuals who are sometimes this new generation of individuals is not the same as it was 20 years ago. The disregard for rules, the disregard for, ankle monitorings, they're cutting those ankle monitorings. They're cutting that stuff up. And so it's the disregard. When we had young people in Indian River just a few days ago over the weekend, literally destroying the facility. And so it's just, we're really in a unique space, in a unique position within our state, within our community, and then the state of violence in our communities continues to rise, and we have to continue to be mindful of that in protecting, or at least attempting to protect the community, and evaluating overall bond and bail amounts. And so, like I said, I respect and I really do appreciate the ability to have this conversation with Kevin and with Senator Thomas, being able for us to go back and forth. This is good, healthy dialogue, and hopefully the people who are listening are getting some tidbits, whether they vote no for it or they vote yes, that they were informed because of this conversation. So thank you, Carrie, and the Bar Association for allowing us to participate.
Yes, thank you, Kyle. Thank you, Kevin. Thank you, Senator Thomas. I'm sorry we weren't able to get to everyone's questions today. I like to end on the note that all three of you said today that there's still more work to be done in the bail reform. Issue 1, whether it passes or not, is not going to solve everything. And it's just really refreshing and uplifting to hear, even if you disagree on a certain point, that there's still more work to be done. And hopefully the work that was done to get issue 1 on the ballot so quickly can also be done to work towards more comprehensive bail reform. So thank you, Kyle, Kevin, Senator Thomas, everyone for being here this afternoon. Sorry we couldn't get to every question. There were a lot coming in, but thank you for taking time to learn more. And everyone, we will see you at the polls on November 8th. So have a great afternoon.
Take care, everybody.